Emerging areas of discrimination law. Managers must also be familiar with several emerging areas of discrimination law. Well, we can discuss the other parts of the same legislation, but I believe that we can specifically discuss on some of the diseases. Let's talk about AIDS in the workplace. AIDS, of course, is a disease. Although AIDS is considered a disability under the American with Disability Act of 1990, the AIDS situation itself is sufficiently severe enough that it warrants special attention. Employers cannot legally require an AIDS or any other medical examination as a condition for making an offer of employment to a person. Organization must treat AIDS like any other disease covered by law. They must maintain confidentiality of all medical records. They cannot discriminate against a person with AIDS, and they should try to educate co workers about AIDS. They cannot discriminate against AIDS victims in training or consideration of promotion. And they must accommodate or make a good faith effort to accommodate AIDS victims. Sexual harassment. Sexual harassment has been a problem in organizations for a long time, and it is a violation of Title 7 of the Civil Rights Act 1964. Sexual harassment is defined by EEOC as unwelcome sexual advances in the work environment if the conduct is indeed unwelcome and occurs with sufficient frequency to create an abusive work environment. The employer is responsible for changing the environment by warning, reprimanding, or perhaps firing the harasser. The codes have defined two types of sexual harassments. In cases of quid pro quo harassment, the harasser offers to exchange something of value for sexual favors. A male supervisor, for example, might tell to suggest a female subordinate that he will recommend her for the promotion to give her a raise in exchange for sexual favors. The other one is the creation of a hostile work environment is subtler form of sexual harassment. A group of male employees who continually make off-color jokes and lewd comments and perhaps decorate the work environment with inappropriate photographs may create a hostile work environment for female colleagues who become uncomfortable working in that environment. As noted earlier, it is the organization's responsibility for dealing with this sort of a problem. Regardless of the pattern, the same bottom line rules applies to sexual harassment, which is called illegal, and the organizations are responsible for controlling it. Employment at will. The concept of employment at will holds that both employer and employees have mutual rights to terminate an employment relationship anytime for any reason, whether with or without advance notice to the other. Specifically, it holds that an organization employs an individual at its own will and can therefore terminate that employer and that can terminate that employee at any time for any reason. Overall, last 2 decades, however, terminated employees have challenged the employment at will doctrine by filing lawsuits against the former employers on the grounds of wrongful discharge. In the last several years, such suits have put limits on employment at will provisions in certain circumstances. In past, for example, organizations were uh, guilty of firing employees who filed compensation claims or took excessive time off to serve on jury duty. More recently, however, the courts have ruled that employees may not be fired for exercising rights protected by law.